Hi, Judicial Watch President Tom Fitton here with a big update on Judicial Watch's historic victory in California for election integrity. In a lawsuit we just settled on our behalf and on behalf of our clients, LA County agreed to remove up to 1.5 million inactive voters from their registration rolls. Obviously, this is a big victory for clean elections, and I thought it was important with you to share the primary document that settled this case. And in the document, you'll hear described the basis for our allegations and how it is we were able to come to a solution with LA County and the Secretary of State of California. So I'm going to read you the full document here for the record and for history, because this is a history-making settlement agreement which will go a long way, not only in cleaning election rolls in California, but I'm convinced nationwide. Settlement agreement was entered into last week, and here it is. This settlement agreement is made and entered into between Judicial Watch, Election Integrity Project California, one of our clients, Wolfgang Kupka, Rue Guyant, Jerry Griffin, Dolores M. Mars, collectively these are all the plaintiffs, Dean Logan in his official capacity as the Registrar Recorder County Clerk of Los Angeles County, and Alex Padilla in his official capacity as the California Secretary of State. Registrar Logan and Secretary Padilla may collectively be referred to as defendants, and all the parties in this agreement may collectively be referred to as the parties. Whereas plaintiffs and defendants are the parties to the action entitled Judicial Watch et al. Versus Logan et al., currently pending before the United States District Court for the Central District of California. And then it goes into the case number. Whereas the parties through counsel have conferred and agreed that this action should be resolved without the delay and expense of further litigation, the parties share the goals of 1, protecting the integrity of the election process by implementing procedures that ensure the accuracy of voter registration through comprehensive maintenance of the official lists of registered voters, and 2, ensuring that California residents are not removed from official lists of registered voters absent the procedural safeguards set forth in the National Voter Registration Act of 1993, otherwise known as NVRA. Accordingly, the parties have negotiated in good faith to resolve this matter on the terms set forth below, with the court retaining jurisdiction to enforce the settlement if necessary. Whereas the state of California is subject to the requirements of the NVRA, and then we cite the specific legal citation. Whereas the United States District Court for the Central District of California has jurisdiction over the action pursuant to 28 U.S.C. Section 1331 and 1345, and the venue is proper in this district pursuant to 28 U.S.C. Section 84C and 1391B. Whereas plaintiffs brought the lawsuit under the NVRA's private right of action, and the court has subject matter jurisdiction over plaintiffs' claims which arise under federal law. Whereas Registrar Logan is the Register Recorder County Clerk of Los Angeles County, California, and is, under California law, the county elections official responsible for collecting and processing voter registration data. Now, I'm skipping some of the citations to the code in this document, the U.S. Code and the California Code. Secretary Padilla is the Secretary of State of California and is the chief elections official. Defendants are proper parties to this action. Whereas the NVRA was enacted to establish procedures that will increase the number of eligible citizens who register to vote in elections for federal office, to make it possible for federal, state, and local governments to implement the NVRA in a manner that enhances the participation of eligible citizens as voters in elections for federal office, to protect the integrity of the electoral process, and to ensure that accurate and current voter registration rolls are maintained. Whereas Section 8 of the NVRA addresses state voter list maintenance procedures for elections for federal office. Whereas Section 8 provides that programs to maintain accurate and current voter registration lists must be uniform and non-discriminatory, must comply with the Voting Rights Act of 1965, and must not remove registrants solely by reasons of registrants' failure to vote. Whereas Section 8 also requires states to conduct a voter registration list maintenance program that makes a reasonable effort to remove persons from the voter list who have become ineligible by reason of death or a change in residence of the registration in accordance with procedures set forth in the NVRA. Whereas under Section 8D of the NVRA, a registration is subject to removal from the official list of eligible voters on grounds of a change of residence if A, the registrant fails to respond to a notice that includes a postage, prepaid, and pre-addressed return card sent by forwardable mail on which the registrant may state his or her current address and which contains specific instructions and information consistent with the language set forth in the law. And the registrant then fails to vote, and B, the registrant then fails to vote or appear to vote or to correct the registrar's mail during the period ending on the day after the second federal election subsequent to the Section 8D2 notice being sent. So in other words, you get the registration, you get the notice, and if you don't respond to the notice or fail to vote within 2 election cycles, that's when you potentially can be removed. Whereas California Election Code 226B provides that the voter registration of any voter whose name has been placed on the inactive file of registered voters for failure to respond to an address verification mailing required by Section 225 and who does not offer to vote or vote in any election between the date of mailing and 2 federal general elections after the date of that mailing may be canceled. California Election Code 2225 describes forwardable address confirmation notices that are being sent to registered voters believed to have changed addresses. Whereas plaintiffs allege in their complaint and have maintained in this litigation that a registrant who meets the conditions specified in Section 8D1 of the NVRA must be removed from voter rolls. Whereas defendants alleged in answering complaint and have maintained in this litigation that the removal from the rolls of a registrant who meets the conditions specified in 8D1 of the NVRA is permissive and not mandatory, meaning they were saying they didn't necessarily have to remove them and they weren't required to remove them. Whereas the state's NVR manual and guidance published by the Office of Secretary of State were informed by that interpretation of the NVRA, and the Office of Register Recorder, County Clerk of Los Angeles County, has maintained a list maintenance program in line with that understanding. Whereas all parties' legal positions constitute good faith interpretations of the relevant statute. So this is where it came down to. They didn't think they needed to remove names, these inactive names, under federal law. We thought they needed to. And we're saying, well, they thought they were doing it in good faith, and we're saying and our allegations were made in good faith as well. Whereas all parties' legal positions, okay, I read that already. Whereas on June 11th, 2018, the United States Supreme Court issued its ruling in Houston versus A. Philip Randolph Institute. The opinion in that case stated that Section 8D, quote, provides that a state may remove a registrant who is, 1, has failed to respond to a notice, and 2, has not voted or appeared to vote during the period beginning on the date of the notice and ending on the day after the date of the second general election for federal office that occurs after the date of the notice. Not only are states allowed to remove registrants who satisfy these requirements, but federal law makes this removal mandatory. Whereas, because of the above referenced language from the Houston decision, the parties agree that this action should be resolved without further litigation and without any admission of liability or wrongdoing by defendants. Whereas the parties agree to work in a fair, reasonable, and collaborative fashion under the terms of this agreement as set forth below. Now therefore, in consideration of the mutual promises and releases set forth below, and for other good and valuable consideration, the receipt and sufficiency of which the parties hereby acknowledge, the parties hereby agree as follows. Number 1, defendants represent, as of April 27, 2018, that there were approximately 1.565 million registrations on Los Angeles County's inactive file of registered voters. All registrations that are on Los Angeles County's inactive file of registered voters but are not currently scheduled to be canceled after the expiration of the statutory waiting period described in 52 U.S.C. sections 20507 D1 B1 should be mailed or address confirmation notice consistent with the requirements of D2, including the notice language specified by the provisions, by March 4th, 2019. In other words, most of these names are going to get the mailing that we talk about, asking them to confirm their current address or any change of address. Register Logan shall make a reasonable effort to determine by February 4th, 2019, which of the registrations in the Los Angeles County's inactive file of registered voters may be canceled pursuant to each of the following provisions. A, all registrations in Los Angeles County's inactive file of registered voters that are associated with registrants who are sent a Section 8D2 notice, who have not responded to that notice, and who have been on an inactive file for 2 general federal elections shall be canceled by February 18th, 2019, unless prior to that time the registrant votes, appears to vote, corrects their voter record, or is otherwise able to confirm the registrant's ability to vote. B, all registrations on Los Angeles County's inactive file of registered voters that are associated with registrants who were sent a Section 8D2 notice, who have not responded to that notice, who have been on the inactive file for a period of time that has included 1 general election, shall be canceled within 90 days following the next general election, unless prior to that time the registrant votes, appears to vote, or corrects their voter record, or is otherwise able to confirm the registrant's ability to vote. All registrations on Los Angeles County's inactive file or registered voters that are associated with registrants who were sent a Section 8D2 notice, who have not responded to that notice, and who have been on an inactive file for a period of time that does not include a general federal election, shall be canceled within 90 days following the second of the next 2 general federal elections, unless prior to that time the registrant votes, appears to vote, or corrects their voter record, or is otherwise able to confirm the registrant's ability to vote. So what that means is that beginning in February of 2019, a group of people may be removed. After the next general election in 2020, another group of these names might be removed. And then after the next federal election, the rest will be removed, who haven't responded as appropriate under law or who haven't voted, as we detail here in the agreement. Plaintiffs may request reasonable assurances that defendants reasonably are making or have made the determinations described in the preceding paragraph. Defendants shall accommodate plaintiffs' requests as long as they are not unduly burdensome. All registrations that come to be placed in Los Angeles County's inactive file of registered voters in the future that are associated with registrants who do not respond to a Section 8D2 notice shall be canceled within 90 days following the second of the next 2 general federal elections occurring after the registration is placed on the list, unless prior to that time the registrant votes, appears to vote, or corrects their voter record, or defendants are otherwise able to confirm the registrant's ability to vote. When a Los Angeles County registrant is sent a forwardable notice pursuant to 52 U.S.C. Section 2057 D2, and if that mailing is not responded to or is returned as undeliverable, Los Angeles County's elections officials shall place the voter's name on the Los Angeles County inactive file of registered voters. The Secretary of State acknowledges that this implementation of Section 8D2 is not inconsistent with NVRA. Defendants will continue to implement programs to identify registrants who have moved or passed away, to send notices pursuant to 52 U.S.C. Section 20507 D2, to place registrations on the inactive file of registered voters, and to comply with the NVRA. Information to be clarified by the Office of Secretary of State. So these paragraphs are under this next section. 8. The Office of Secretary of State shall remove from its website a document titled California NVRA Manual, updated August of 2015. In any replacement for this manual, the Secretary of State shall, after the instructions provided in the Voter List Maintenance Chapter 5 of that manual, to conform to the statement cited above from Usted versus A. Philip Randolph Institute. So they're going to change their NVRA manual, the Secretary of State is, to update it to include the language from the Supreme Court talking about the requirement to remove certain names. The Office of Secretary of State shall not send, the Office of Secretary of State shall send a written advisory to all county clerk registers of voters in California that the cited language from USTED indicates that current federal law requires the cancellation of a registrant who has failed to respond to a Section 8D2 notice and who then fails to vote, offer to vote, correct a registrar's notice, record, or otherwise have their eligibility to vote confirmed for a period of time, including the next 2 general federal elections. And then deceased registrants, people who are dead. Consistent with the NVRA, defendants agree to take reasonable steps to review their ability to identify registered voters who may have died in other California counties or in other states, including reviewing any existing contracts relating to this subject, and will review the use of the Social Security Administration's Death Master File for that purpose. So they're going to take reasonable steps to clean up the rolls of dead people. Reporting. In January of each year, defendants shall communicate in writing with Judicial Watch, describing in summary Los Angeles County's existing programs, activities, and procedures for complying with the list maintenance requirements of Section 8 of the NVRA, including programs relating to felons and those adjudicated mentally incompetent. Plaintiffs may request reasonable clarifications or explanations in a responsive writing to defendants. Defendants may respond as they deem appropriate. During the course of the action, Judicial Watch filled out the applicable forms, followed the applicable procedures, and paid any applicable fees set forth in California regarding a request for an official voter list, and defendants provided the requested voter list to Judicial Watch. If in the future any of the plaintiffs fill out the applicable forms, follow the applicable procedures, and pay the applicable fees set forth in California law regarding a request for an official voter list, defendants will follow applicable statutory and regulatory requirements and procedures. In other words, we want to be able to get the list in the future if we ask. In January of each year, defendants shall provide the following information to Judicial Watch for the sole purpose of ascertaining compliance with this agreement: the number of active registrations in Los Angeles County, the total number of registrations in Los Angeles County's inactive file of registered voters, the number of registrations placed in Los Angeles County's inactive file in the past year, the number of registrations that have been continuously on Los Angeles's inactive file or that have shown no voting-related activity for 2 consecutive federal elections, 2 consecutive general federal elections, 3 consecutive general federal elections, 4 consecutive general federal elections, and 5 or more consecutive general federal elections. The number of Section 8D2 notices at Los Angeles County within the past year sent to registrants, received back from voters confirming registration, received back confirming registration should be invalidated, received back as undeliverable, and sent but did not receive back, or all updates to or new manuals, formal guidance, advisory opinions, training manuals, facts, frequently asked questions, and administrative regulations governing or concerning how Los Angeles County is to comply with the list maintenance requirements of Section 8 of the NVRA, including programs relating to felons and those adjudicated mentally incompetent. So enforcement and term. The parties to this agreement must employ best efforts to defend it against any legal challenges by non-parties. The parties acknowledge and agree that this agreement shall become effective upon dismissal of this action by this court, with the court retaining jurisdiction to enforce this agreement if necessary, which dismissal occurred on September 5th, 2018, and to execution by the last signatory to this agreement, which is the effective date. We all signed this last week, I think, or it was all finally signed last week. The parties' obligations under this agreement shall remain in effect, and its terms shall remain enforceable upon all parties through a date that is 60 days after the date on which the results of the general federal election on November 2024 are certified, on which date the agreement will terminate automatically unless the parties mutually agree to extend it or the court determines that the defendants have not substantially complied with its terms. The parties agree to work cooperatively to ensure that the court shall retain jurisdiction over this action and to enter such further relief as may be necessary for the effectuation of the terms of this agreement. Each party shall bear its own costs and fees in connection with the action. The signatories to this agreement represent that they are authorized to execute and bind themselves or their respective organizations or agencies to this agreement. And then it goes through a list of releases that I won't read to you because it will not help you. And then, of course, I signed this agreement on behalf of Judicial Watch, and the other appropriate parties signed as well. So as I point out, this is a big victory for election integrity, and I think it's interesting to hear this settlement agreement. And just to be clear, this is a mutual settlement agreement. So we're happy, and the state of California is happy, and Los Angeles County is happy. And we may not share the same outlook as to how to handle voter fraud generally or how to handle the NVRA, but we came to terms here. And this is the way civil litigation sometimes is settled. It's settled civilly. So we're pleased that the state of California, the Secretary of State there, Secretary of State Padilla, did the right thing in settling this case. Los Angeles County, their officials there also did the right thing in settling this case. So we're pleased that they were doing this, and then we're pleased that after finally 20 years, they're going to begin the removal of people from the election rolls who are probably not supposed to be there. And it will take some time for this process to be completed. It will begin almost immediately, but it will take a time for the full 1.5 million up to 1.5 million, because of those numbers, there will be people who will remain on the list because they are still eligible to vote, as we detail in the settlement agreement. But this is an important settlement agreement. It sets not only obviously a precedent in Los Angeles County, but in California, other counties that are problematic are, I would think, going to have to change the way they are maintaining their voting rolls and make them cleaner. And nationally, I think this is going to be important as well, because California is not the only state with this problem. We already have a consent decree in Kentucky that had a similar problem, and there are other states where they have too many people on the rolls than who are eligible to vote, which shows they aren't taking reasonable steps as required under the NVRA to clean up their rolls. So thanks to you, we were able to litigate this over the last year or so. We spent years investigating and pushing our election integrity efforts on the NVRA. We now have historic 3 agreements. The Ohio agreement, where we settled in Ohio, which was the basis, and it was at issue in the Houston case that I talked about in the settlement agreement, so that our settlement in Ohio was vindicated by the Supreme Court last year. And based on that, we were able to come to an agreement, as you can see from this settlement agreement, with California, Los Angeles County to finally begin cleaning up the rolls. And I expect that will be the case in other places that we look at that have problems with dirty voting rolls. And you know, to close it out, it's a truism. Dirty election rolls can mean dirty elections. And the opposite of that is also true. Cleaner election rolls means cleaner elections. So thanks to Judicial Watch and our clients in California, and frankly the Secretary of State of California and Los Angeles County, they'll now have cleaner elections, at least in Los Angeles County, and I expect statewide as a result of this historic settlement agreement. Thank you for your support that allows us to do this important week, and I'll see you next time with our Judicial Watch updates.